You're thinking about bringing a lawsuit against your doctor and wanted to know about evidence. Can we go ahead and get something introduced into evidence before your trial actually starts? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, we can. But now here's the mechanics of what it is I'm talking about. Let's say you sued your doctor for medical malpractice, and you have a medical expert to confirm that you have a valid basis for a case. Okay, that's great. Now the defense has denied your allegations throughout the entire course of your lawsuit. All right, so now your case is going all the way to trial. So 2 or 3 years down the road, when your case finally comes up for trial, we are now approaching jury selection. And before we reach jury selection, I want to get something into evidence. Now, what does that mean? Well, you know, during the course of trial, we have to introduce certain things for the jury to evaluate, for things that our expert needs to evaluate. And we do that by offering them into evidence. And as long as there's no objection from the other side, the judge will allow us to bring that information into evidence so the jury can ultimately look at it and hear it and see it and read it. Okay? But now, is there an instance where we can go ahead and ask the judge before the trial even starts to introduce something into evidence? And the answer is yes, there is a procedure to do that. We call that a motion in limine. Now, a motion is nothing more than a formal request to the court to take action, to do something. In limine is a fancy Latin term that basically says, hey judge, before we actually start this legal proceeding, we'd like you to make a decision on whether or not we can do something that we're asking you to do. So in this instance, we want medical records to be introduced into evidence. And now, before I actually make this request to the court, I have gotten permission, consent from my opponent, the defense attorney, because I wanted to make sure that there was no legal issue associated with getting this record ultimately into evidence. Now, we have sued the hospital. The attorney represents the hospital, and I've asked the attorney to consent to allow me to put this medical record into evidence. Now, the hospital record has been certified as being accurate and thorough and detailed, and it is an exact copy of the record maintained in the hospital. So there's no issue or dispute about what's contained in that record. During the course of trial, the defense attorney may turn around and say, hey judge, there are certain parts of this record that the jury does not need to see, in which case the judge may agree and simply allow us to redact, to remove portions of that hospital record. But getting back to the question I raised in the title of this video, can I get this evidence introduced into evidence before we actually start the trial? And the answer is yes. I can go ahead and get permission from my opponent. He can agree. If he agrees, great. Now it's on consent, which means that now at the time of trial, I no longer have to go through the entire process of getting something admitted into evidence and authenticating it and confirming that it is accurate and comes from the hospital. We've already done that before the trial has started. So now during the middle of my questioning, I can simply say, Your Honor, at this time I'd like to offer this document into evidence. And now the judge will already know that my opponent has consented, and this will be marked into evidence, and I can continue asking my questions. There may be other reasons why I would want the judge to take action before your trial actually starts. There may be a topic involved in your case which might have been off limits. Let's say the case involves improper medical care in the emergency room. And now you just so happen to have come into the emergency room with a blood alcohol level of 0.32, right? And now that's because you were arrested for DWI. Now what does that have to do with the improper medical care that you received in the emergency room? In our particular case, in this example I'm using, let's say it has nothing whatsoever to do with it. In that case, I might actually ask the judge to keep out that information about your DWI, to keep out your blood alcohol level. In all likelihood, I'm going to have a very difficult time keeping that information out. Why? Because the defense will likely argue that that is connected, directly connected with the treatment you received in the emergency room. And if it is, it's likely I'm not going to be able to keep that information out. And by the way, doing this saves time and energy and resources during the course of trial. So now we don't have to stop the proceedings, we don't have to mark the exhibit, it's already pre-marked, and now things will move along much smoother. Many times when we make this motion, it is not to the judge who is now going to be trying this case, but rather to the judge who has been in charge of the discovery phase of your case. They may turn around and say, listen, counselors, it's too premature. Let the trial judge make this decision. Deal with it at the time you begin this trial. So why do I share this great information with you? I share it with you just to give you a sense of what really happens here in New York in these medical malpractice cases. I realize you're likely deciding whether or not to bring a case or whether you even have a valid case. Well, if you have not yet started a case and your matter happened here in New York and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.